A Supreme Court ruling just changed what judges must look at after a police shooting during a traffic stop. And if you think only the last split second matters, that misunderstanding could cost you your rights when it matters most. Quick question before we continue. Are you subscribed yet? Because what I'm about to break down is not internet rumor, not fear bait, and not courtroom fantasy. This is the kind of update that can shape what happens after a stop, after a search, and after an officer says he feared for his life. If you carry, keep a gun in your truck, or just want to know your rights when police contact happens, hit that subscribe button right now. I cover this stuff so you don't get blindsided. Here's what just happened. The case is Barnes v. Felix. It came out of Texas. A police officer stopped a driver named Ashty in Barnes over suspected toll violations. At first, this looked like a normal traffic stop, but then everything moved fast. The officer said Barnes was digging around in the car. Barnes said the car was a rental and that he might have identification in the trunk. The officer told him to open the trunk from inside the car. Then the officer ordered him out. Instead, the car started moving. The officer jumped onto the doorsill and fired into the car. Barnes died. Now, this is where it gets interesting. The lower courts looked at only the final 2 seconds. Just 2 seconds. Their basic idea was simple. If the officer was in danger at the exact moment he fired, that was the end of the story. Nothing else mattered. Not what happened before. Not how the stop began. Not what commands were given. Not whether the officer's own actions helped create the danger. Just the final flashpoint. And that is the part the Supreme Court rejected. The court said you cannot review a police shooting with what was basically tunnel vision. You have to look at the totality of the circumstances. That just means the whole picture, the full chain of events, the moments leading up to the use of force, the words, the movements, the timing, the choices made by both the officer and the person stopped. Let me put that in plain English. Most people think a case like this turns only on one question. Was the officer scared right before he pulled the trigger? But the truth is more complicated. The court said judges cannot put blinders on and ignore everything that happened before the shooting. If the full story matters, then the court has to look at the full story. And yes, I need to say this because legal accuracy matters. You may see some people call this an 8-to-1 bombshell. Slow down. The core ruling in Barnes v. Felix was unanimous. Every justice agreed that the narrow moment of threat approach was too limited. There was also a separate opinion from Justice Kavanaugh, joined by several others. He stressed how dangerous traffic stops are for officers. That separate writing is one reason for the framing. But the key point is this. The court was united that judges must look at more than the final instant. Why does that matter to you? Because this is not just about one traffic stop in Texas. This is about how courts judge police force when state and local officers use it on regular people. And that is where both the 4th and 14th Amendments come into play. The 4th Amendment is the part of the Constitution that protects you from unreasonable searches and seizures. A seizure is a legal word, but the idea is simple. If the government stops you, grabs you, or arrests you, if they use force to control you, that can be a seizure. So when an officer uses force during a stop or arrest, the 4th Amendment is often the rule that applies. But here's the part nobody explains well. The 14th Amendment is what makes those protections matter. It makes them matter against state and local governments. In simple terms, the 4th Amendment is the right, and the 14th Amendment is the bridge that carries that right into your encounters with city police. It applies to county deputies and state troopers. This decision affects both amendments. Your protection against unreasonable force is judged under the 4th Amendment, and the 14th makes it bind the states. Now let me break down why that should matter to gun owners more than almost anyone else. A huge number of gun cases do not start with a SWAT raid. They start with a traffic stop, broken taillight, expired tag, speeding, rolling a stop sign, toll issue, lane change, tinted windows. Then the questions begin. Where are you coming from? Is there anything in the vehicle? Any weapons? Are you carrying today? Your answer, your hands, and your timing can change everything. The officer's reaction can turn a routine stop into a life-changing event in seconds. Imagine this hypothetical example to explain this. You are lawfully carrying. You get pulled over. Your wallet is in one pocket. Your permit is in another. Your registration is near the console. That is exactly where your handgun is stored. The officer gives fast commands. You are trying to comply. He thinks you are reaching too quickly. You think you are following directions. In the old narrow view used by some courts, a judge might zoom in on just one movement, just 1 second, just one moment of fear. But after Barnes, the court is supposed to look wider. What was the reason for the stop? What commands were given? Were they clear? Did you announce the firearm? Did you move only after being told? Did the officer escalate too fast? Did the earlier moments change what a reasonable officer should have understood? That does not mean you automatically win. Don't make that mistake. This ruling does not say every shooting is illegal. It does not say every officer is liable. It does not say a gun owner gets a free pass. What it says is that courts cannot ignore the setup and look only at the explosion. If you're finding this helpful, imagine what you will learn in my next video about the 5 words. These words can protect you when police ask about your gun during a stop. Subscribe now so you don't miss it. Knowing the law after a stop is good, but knowing what to do during the stop is even better. Here is the second big thing most people get wrong. They hear this ruling and think the court will always blame the officer. Not so fast. The Supreme Court did not decide that question here. It did not say how much an officer's own bad decisions should count. It said the lens was wrong. Chopping the event down to a tiny sliver of time was the error. The court sent the case back. Now the lower courts can look again using the right lens. That is a big difference. Think of it like a security camera. One court was watching only the last 2 seconds of the video. The Supreme Court said, no, you need to rewind and watch the whole clip. You must do this if those earlier moments help explain what really happened. That is huge in theory. But in practice, lower courts still have room to disagree about what the full video means. And there's another layer, qualified immunity. That is the judge-made rule that often protects officers. It protects them from civil lawsuits unless the law was clearly established. I know that sounds technical. So here's the simple version. Even if a court thinks your rights were violated, you may still lose damages. This happens if the court says the officer did not have clear warning from earlier case law. So Barnes helps plaintiffs by giving them a wider frame, but it does not erase every shield officers have. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney. Let me explain why the separate opinion matters too. Justice Kavanaugh joined several others in a separate writing. He spent time stressing that traffic stops are dangerous for officers, especially when a driver pulls away. And honestly, that matters for gun owners because it shows you how the court is thinking. Even when the court gives more room to review police actions, they still remind courts about officer safety. They should not judge officers with perfect hindsight from a quiet courtroom. So what does that tell you? It tells you this ruling is not anti-police and not magically pro-defendant. It is more precise than that. It says context matters. But context works both ways. It shows the court still takes officer danger very seriously. That means future cases will turn on details. Small details like hand placement, tone of voice, distance, lighting, and warnings. Prior movements matter. Whether the officer could see inside the car matters. Whether the suspect was fleeing matters. Whether bystanders were nearby matters. All of it can matter in the final judgment. Here is what shocked me when I really dug into this case. A lot of rights are not lost due to lack of rights. They are lost because courts use the wrong frame when looking back. If the frame is too narrow, you lose the story. And when you lose the story, you can lose the case. That is why this matters far beyond one stop. Let's say an officer claims he saw a threatening movement right before using force. After Barnes, the court should not just freeze that one frame like a screenshot. They must look back. It should ask what led up to it. Was the person complying? Was he confused by mixed commands? Was the stop for a violent felony or a minor traffic issue? Was there warning? Was the officer's position avoidable? Did earlier facts make the later danger look different? For gun owners, this matters because lawful possession can be misread in tense moments. A holstered pistol can look like a fast draw. Reaching for a registration card can look like a grab. Turning your torso to unbuckle can look aggressive. None of that means you should take risks. Actually, the lesson is the opposite. Here's the practical takeaway. First, keep your hands visible. Second, do not reach for anything until told. Third, if your state requires disclosure, do it early. Fourth, use plain language like, "Officer, I want to comply. Please tell me exactly how to move." Fifth, do not argue roadside law. The courtroom is where Barnes helps. The highway is for survival. Hey, 73% of people watching channels like this never subscribe. Do not be part of that group. Join the liberty-minded viewers who want the truth before the next ruling drops. Hit subscribe now. But wait, there's something even more important. Barnes is about force during a stop or arrest. It does not rewrite every police encounter rule. It does not change your duty to obey lawful commands. It does not make it smart to educate the officer on constitutional law at midnight on the roadside. And it definitely does not mean you should test the edges of your rights in a tense encounter. This is the part that could save you real trouble. Court victories happen later, sometimes years later. But your safety depends on what you do in the first 10 seconds of that interaction. Most people think constitutional rights work like a shield that pops up automatically in real time. The truth is harsher. Rights often become tools used later by judges and lawyers reviewing the facts. So your job during the stop is not to win the legal argument on scene. Your job is to go home alive, avoid sudden movements, and keep the officer from guessing. You must preserve the facts for later. Let me tie this back to the 14th Amendment again. The Fourth Amendment gives the basic protection against unreasonable force. The 14th makes it apply to states. So when the Supreme Court says courts must look at the totality of circumstances, it affects local cases. That rule matters where you actually live, in your city, your county, and your state. So yes, this decision is a big deal. Not because it made every case easy, but because it stopped a shortcut. It told judges they cannot pretend the first part of the encounter never happened. And that can change outcomes. This information matters right now, not someday. Subscribe now, because the next video breaks down what to say when an officer asks about your firearm. If you wait until you need that information, you waited too long. Here's the bottom line. Barnes v. Felix tells courts to look at the whole encounter, not just the final heartbeat before force. For gun owners, that matters because context is the difference between rights seen or erased. If this video helped you, subscribe and share this with one person who carries a firearm. Rights matter on real roads and real stops with real consequences. Stay safe out there. Final simple disclaimer, this video is for education only. Laws vary by state and facts always matter. If you are dealing with a real case, talk to a qualified attorney right away.